Good afternoon, everybody, and welcome to the panel of Chief Justices. Since the establishment of the Appeals Court in 1972, there have been 7 chiefs. Alan Hale from 1972 to 84, John Graney from 1984 to 89, Joseph Warner from 89 to 2000, Chris Armstrong from 2000 to 2006, Philip Raposa from 2006 to 2015, Scott Kafker, 2015 to 2017, and Mark Green, 2017 and ongoing. At this celebration of the Appeals Court 50th, we are extremely fortunate to be joined today by Chief Justices Graney, Armstrong, Raposa, Kafker, and Green, and we cannot thank them enough for making themselves available to share their experiences and their insights.
Our plan, and we do have one, is to begin by a brief recount of the history of the court, posing questions to each justice. After that, we're going to turn to some broader topics in which we anticipate that the experience, the vast experience that you see up here, can be brought to bear on some of the current problems and possible future processes that might help the court in the future. Just one point of context to consider as you listen to the discussion today. Were you to be offered a prestigious job in the public eye, one that everything that you do would be closely examined, and were to ask about the details of that job, you would find out that you cannot decide who to hire. You can't get rid of anybody. You can't decide how much to pay them or whether to have a bonus or not. In fact, you can't even really tell them what kind of results to bring in. So the challenges inherent in this position, while we all kind of know them in the back of our minds, generally are ones to keep in mind as we discussed today. I'm going to start, as did the court, with Chief Armstrong. Chief, you were one of the first 6 appointees when the court was established in 1972. And you started with a backlog. Can you explain a little bit about that, please?
Yeah, that's pretty easy. The legislation that created the court passed in I think it was around June or July, I think June of 1972. And from the date it became effective until the court actually came into existence, all the cases that under the legislation should be docketed in the appeals court came to the appeals court rather than to the SJC. So and with no court in existence to grant direct appellate review, I shouldn't say grant, to suggest to order direct appellate review, they just piled up on the appeals court docket. We actually came into existence as a court in November. And so that was half a year of backlog right there. The SJC, thinking that we would handle a lot more cases than we actually did, transferred about a couple of hundred cases, more or less, to the appeals court for decision, exercising their power under the legislation of transferring cases out. It was the down elevator, as we used to call it. And so that was the reason that we started with a backlog when we came in.
What did you try to do to deal with that?
There was not much we could do. We didn't have at that point any modus operandi, any method of proceeding, any principles in mind, who would get what cases, whether it would be equal among judges. We assumed all cases had to be heard, as indeed they did at the time. And so we simply started chipping away at cases. I think we broke up into two panels of 3 apiece. And each panel would meet 3 days. We'd have 6 cases on the daily list, and you would end up with 6 cases to write at the end of the month. And the trouble is that method of allocating as the cases came in didn't take account of the fact that cases were coming in at a much faster rate than 6 a day. So we were falling behind. Every year we were further behind than we were the year before.
So I take it that the prospect of additional judges started to look pretty good at an early stage?
We didn't, I don't know what we thought at the time. We weren't really focusing on the problem. It was just that there were these cases there that had to be heard, and we'd hear the ones that had been there the longest. And the longest hadn't become unconscionably large yet.
But you did eventually get additional judges.
Oh, yes. We badly needed it. It was obvious, I think, to anyone who really thought the problem through. It was evident very early on that we had been totally misconceived in terms of number of judges we needed to do the work if we were going to hear cases at the pace of 6 per judge per month.
So in 1978, I believe you got Justice Graney, Justice Cass, as well as Justice Peretta and Justice Drebin.
Right. We did, and it was I have to give credit for Michael Dukakis, who was governor at the time. He sent us a wonderful crop of new judges to bolster the court.
Well, I'm going to ask a question of one of those wonderful new judges, which is Chief Graney. What were your impressions of the court when you first arrived with the other expansion judges?
Well, I had already formed a good impression because I was working in the Superior Court at the time, and I diligently read their decisions, which I regretfully say some of my colleagues did not, nor did they read the SJC, because they were older judges that just weren't used to keeping up that way. I thought the decisions were lucid, clear, thorough, and correct.
And what about that backlog? How daunting was that to the newer judges?
Well, I don't know, since I was by that time one of the veteran judges, not one of the newer judges. But so it's probably, but still at that point, I was, unaware of the concept of the problem, that the cases were coming in a lot faster than we were deciding them.
Judge Graney, I remember hearing from someone during our interviews of the chiefs that you had this unbelievable work ethic and would take home stacks of cases to write every night. I don't know whether you did that on the bus or the train to and from Springfield or what, but that you were trying desperately to shovel the stuff out. Is that a fair comment by one of your colleagues?
Well, that's a fair comment. I was sort of the resident judge on the bus that went back and forth from Boston. And it was about sometimes a 2.5-hour trip. And so I said, well, I can't just sit here and read the Globe and those kinds of things. So I took files with me home and files with me on the bus. And I would work on them because I was determined one way or the other we were going to work away on that backlog and try to get as current as we possibly could. But as Justice Armstrong says, it was an impossible task because once the lawyers caught on to how good the court was and the SJC wanted to transfer cases, it just came in at an overwhelming rate.
And then 6 years later, you became chief. And were there any innovations that you initiated at that time in an effort to get a handle on all of this work?
The principal one with respect to getting a handle on the work was to convince the SJC that the 128 process should be extended to criminal cases. And the first reaction was, oh my God, you're going to decide cases in unpublished memoranda and maybe do one-liners, and that's not right for somebody who's going to spend years in prison and all that kind of thing. So I eventually convinced Chief Justice Hennessy, who convinced his colleagues that we would do it diligently, we would deal with all the issues on appeal, and the memorandum would be thorough. Memorandum decisions and 128s would be thorough and in some cases very lengthy. Now I must confess, and maybe I have to go to confession over this, that I lied a bit because at times we issued one-liners that said the decision is affirmed for the reasons stated by the judge in his memoranda in the Superior Court.
Well, you also took on some extracurricular activities at that time, including one that frankly is very near and dear to my heart, which was you co-chaired the gender bias study. Can you tell us a little bit about that project?
Yes,
because it made a huge difference in many people's lives.
Yeah, for those who were with us this morning, I apologize for repeating some of this. Chief Justice Hennessy called me down and said, I want you to be co-chair of the gender bias study with Justice Abrams because we need a male on the committee. And you don't turn him down, like I said. So I said, sure, I'd be happy to do it. So we then set about assembling a team, which was an extensive team of lawyers, experts, and others, hired the Wellesley College Research department from Wellesley to help us assemble the information, engaged in all kinds of investigative techniques from war stories all the way to polls and that kind of thing, collated the results, and then were shocked by what we saw. So we put it into the report, and it became the catalyst, I'm happy to say, for the beginnings of reform within our judicial system, where women were going to get an equal break on promotions and appointments to the bench and a few other things. And I'd have to say that the governors were very responsive, too, when it came to the appointment of clerks and judges in that regard. So we tried to move it forward a bit, and I think it's worked out.
Thank you, Justice Graney. I'm going to turn to Chief Raposa for a minute. We're going to be getting back to you about your time as chief, but there is actually something I wanted to raise. When Chief Justice Graney was elevated to the SJC, there was, Joseph Warner took the reins. And then later, unfortunately, Joseph Warner became ill. And you became a judge on the appeals court at a time when then Justice Armstrong really had to sort of step forward. Mm-hmm. Can you tell us a little bit about that time, and then also how, when Chief Justice Warner retired, Chief Justice Armstrong ended up being selected as chief?
Sure. When I arrived at the court in 1998, as Justice Cohen just said, Chief Justice Warner was already quite ill and was not able to come to the office regularly. So as a result, the day-to-day operations of the office fell to Chris Armstrong. He was the senior judge on the court. He was also the one remaining judge of the original 6 on the court. But it wasn't just as a matter of his seniority that he took on that responsibility. It was because it was clear that he had the confidence of all of us, and that there was a strong desire on the part of all of the justices that Chris take the reins, which he was willing to do, which pleased us all. But at the same time, Chief Justice Warner was still the chief. In 2000, Chief Justice Warner passed away, and at that point, the question was who was going to be the new chief. At that time, we had 14 statutory judges and 4 recall judges. And it was very clear very quickly that all of us were of the view that no one other than Chris Armstrong could or should take on the responsibility as chief. So what we did was we generated a letter signed by all 14 justices and the 4 recall justices, in which we asked Governor Cellucci to appoint Armstrong as our Chief Justice. We were very pleased, of course, that the governor agreed with us that that was the right course to take, and he did appoint Chief Justice or Justice Armstrong as Chief Justice. So in sum, it really wasn't based on seniority per se, but on the fact that unanimously all the justices believed that Chris Armstrong was the person to lead the court into the 21st century, and thankfully the governor agreed.
Justice Armstrong, you certainly took the court leadership at a difficult time and hadn't managed expectations the way one is taught to in law school. Can you tell us what your priorities were when you became chief?
Yeah, it was, to me, it was very evident from the very beginning that we were understaffed. We needed more judges. We had needed more judges for a long period of time, and that we should go to the legislature and the governor and ask for more judges. The process, since the legislature was already in session, was that no bills could be introduced except through the governor by way of special message. And when we went to, it was Rudy Cass, Judge Cass, who knew Len Lewin, who was a lawyer, who was Governor Cellucci's chief counsel, and arranged for me to meet him and the governor, and came over with me and got it off to a very good start. So kudos to Rudy on that at that point. Len Lewin turned out to be one of the most delightful people I ever saw. That was my old job under Frank Sargent. Here he was with that job under another Republican governor. We hit it off well. He talked with me, said, if we're going to, the judges as a group were very gun-shy about going to the legislature and asking for anything. I think they were, I think it was the unlikelihood of getting a favorable result that led them to keep the request modest. And so we went over proposing a 3-judge increase. And it was Len Lewin who convinced us that if we want to get 3, we should ask for 5. That way we'd have judges to trade for. And so the governor's message asked for 5 judges, new judges for the appeals court. And it was later on that when it was in the legislative process that it came to Tom Finneran, who was then the Speaker of the House. And I knew Tom Finneran pretty well because I had been going to the State House for so many years, telling them what a basket case the appeals court was and how we desperately needed more judges. And so he had me in, and we worked out the details. It was he who wanted to go through how much of a backlog do you have, how long is it going to take you to get through that backlog, and how many new cases are coming in at the same time. And that was a pretty formidable number and rising every year. So it was that calculation that if we appointed 11 judges of the appeals court, that we could get rid of the backlog in 3 years. And so that was where the 11 figure came from. And then it was attributed to a lot of different sources. A Boston Bar report on the problems of the appeals court just happened to come out with 11 judges as the right answer. And Rudy again was introducing me to the editorial boards of the Boston newspapers and also the Springfield papers, all of whom were supportive. And so it was everyone was asking for 11 new judges, and that was the way it ended up. And it was I was racked with worries at the time about where would I house them. We didn't have any spare offices. How would we create 11 new offices? Where would we get law clerks? We didn't have any provision in the budget. And the legislative people told me, don't worry about that stuff. Go for the big thing, the number of judges. The rest of it'll take care of itself. And it did, eventually. So,
Chief Raposa, let me ask you, as someone who was a relatively new judge, when the 11 of us expansion judges suddenly arrived on the door over a period of a few months. Mm-hmm. But what were your impressions of that expansion, and what, if anything, did you do to help acclimate people?
Well, I think there were 2 levels at which we were relieved. First, that we were soon to be joined by 11 new colleagues, but also relieved at the quality of the people who were coming to the court. Given, as Chief Justice Armstrong said, that he originally went in pitching for 3 judges, was convinced to ask for 5, and then somehow in the mystery of the legislative process, we were given 11. Our concern was, who were these extra judges going to be, and by what process were they going to be selected? Would there be legislative influence? Exactly what would be in play? And any concerns we had were quickly dispelled by the quality of the people we received. It was not just the number, not just the quantity, but the quality of the people we received that really was greatly appreciated by all of us. In terms of where we would put them, as Chris said, it reminds me of the phrase, if you build it, they will come. And I guess if they come, you will build it. And while we weren't building anything, Chris arranged to have an entire floor at the so-called new courthouse, so-called since the WPA days in the 1930s, that we would try to house as many of the judges on that floor as possible. And I spoke to Chris and offered to be one of the sitting judges who actually would join our relatively new colleagues on that floor. And as yesterday Justice Mills mentioned, I sat next to him, and as any of you who heard his comments yesterday realize, while I was supposed to be there to help mentor him, he taught me an awful lot that I had never known before. So it was a mutually beneficial arrangement. Of course, the challenge was not just that we had 11 new bodies present, but the court at that time had we had 14 judges and 5 recall judges. Of that 19 judges, 7 had served on the appeals court for 20 years or more. And the average judge on the appeals court at that point had served for an average of 13 years. So we were now not only getting 11 new people, but 11 new people who had never served on the court. So there was a learning curve, not so much as to the law perhaps, but as to what are the protocols, procedures, how does collegiality work, how does this operation called the appeals court function. And I thought that I could perhaps be of some assistance in that regard. While there were formal mentoring arrangements and informal mentoring arrangements where all judges, even the most veteran of judges, pitched in and helped with the new judges, I thought, and I think it proved to be true, that some of the new judges were just afraid to ask what they thought to be stupid questions. Not about the law, but about where do I sit, where do I stand. It reminds me of my first question of Chief Justice Warner when I went to see him. I went in, met with him, and asked him what advice he wanted to give to a brand new judge on the appeals court. There was silence. He thought. He looked at me and said, "Wear a white shirt when you sit."
Well,
that proved to be invaluable advice.
But was that the advice that you ultimately gave people when you became chief in 2015?
Well, I don't think they were as deferential as I, but I think most people ended up wearing something white someplace.
And tell us a little bit about your time as chief, because that was pretty eventful too.
Well, it was, because at that point, now we're talking in 2006, when I was appointed chief. Shortly thereafter, if any of you were old enough to remember, and I think some faces here are perhaps too young to remember, starting in 2007, the country faced the beginning of the unraveling of the economy, which somewhat peaked in 2008 and 2009. The stock market crashed. Lehman Brothers declared the largest bankruptcy in U.S. history. It was a very difficult time, and state tax revenues dropped off dramatically, and the state budget took a plunge as well. So my immediate role, as I saw it, on the administrative side, was to make sure that the least amount of fiscal harm came to the appeals court during this very difficult period. The way in which I approached that was in going to the State House, and Chris has already mentioned his going to the State House, it became a routine practice for me. Monique used to joke that I spent more time at the State House than at the courthouse, but it was necessary to do. It was to, first of all, emphasize, because we, working in the court system, understand it to an extent, but we know who's who the players are. It's not always that clear on the legislative side. So, for example, when I would go over there, they would think, well, this is like the Chief Justice of the District Court, which is a department of the trial court. And I had to explain that we had our own line item in the budget. I was appointed by the governor, just like the Chief Justice of the SJC. And so there was a certain educating function that had to be performed. But establishing that we were independent of the trial court and the Supreme Judicial Court was very important. And the example that I always gave to create an image that would stick in people's minds were, you've got these twin peaks. You've got the Supreme Judicial Court, and you've got the trial court. And the appeals court is between them, sort of like Switzerland. And everybody likes Switzerland. And the reason for making that point was there was something of a testy relationship at this point. Unlike during the salad days of Chief Justice Armstrong, where Finneran was very favorable, it wasn't that way, at least in terms of the judiciary as a whole. with the leadership at the State House. There were issues that arose shortly after the fiscal crisis, which was the probation crisis. It was a series of crises. The probation crisis, in which hiring practices at the trial court were routinely on the front page of the Globe. They were criticized for hiring practices. The SJC was criticized for lack of adequate oversight. And I had to explain, I really did have to explain to people in the legislature that we don't have probation officers in the appeals court, and we don't have any supervisory or oversight responsibility for the trial court. So let us stand on our own merits. And that was, in the end, successful, developing close personal relationships with people there. I remember sitting in the chamber or lobby of the Speaker of the House at that time, Bob DeLeo, and ending up in conversations about how his Italian family and my Portuguese family worked in the factories and the mills when they came to the United States. It wasn't to become his friend, but it was to establish a relationship in a sense of trust, credibility, where he would at least give me a hearing, which they did, resulting in the fact that the first year of the fiscal crisis, the budget of the Supreme Judicial Court was cut by 14%. The budget of the trial court was cut by 10%, and ours was cut by 5%. The next year, their budgets continued to go down. Ours went down, but now only by 3%. And the following year, our budget actually started to go up. And there's the judiciary as a whole, the budget continued to go down. So I think relationships were very important, and I think as it was played by us, it was a successful effort.
Justice Kafka, you were one of the highly anticipated 3, 5, 11 judges who joined the court in 2001. And you served as an associate justice until 2015 when you succeeded Chief Justice Raposa. You spent 2 years in that role before getting kicked down to the second floor. What did you consider important to accomplish when you became chief of the appeals court?
So I had realistic expectations when I became chief, because I'd been an associate justice, as Andrew said, for 13 years, and knew, like everyone in the audience, associate justices don't like to be told what to do. So I figured I had limited power and capacity to implement change, so I focused on a few things, and Justice Seifer was not in charge, despite the rumor. It was actually Monique Duarte who really ran the appeals court during that period. So I looked at what I said to the Governor's Council just to remind myself what it is that I promised to do. So I basically said one sentence: the appeals court has to keep up with the challenges facing the bar and society at large. And the bar is going through a period where it has to work faster, it has to be more technologically sophisticated, it needs to be more specialized, and it also needs to be more diverse. And that was really my focal point. We, during our first year, and really Joe Stanton and then Justice Green really did the hard work, but we went from a paper court to a digital court in basically 6 months. We had e-filing. We stopped distributing paper around the court. Everyone went with an iPad. Now, there were resistors. I see Judge Sikora out there. He had his dictaphone, and he wouldn't give it up. And Justice Cowan insisted on his yellow pad, so he never touched the iPad, as far as I can tell. He must have given it to his grandchildren. Is that right, Judy? And Justice Traynor kept using the fax machine. But, you know, a chief knows when to hide from the big cats, and that's what I was doing. And I, you know, knew when to declare victory, so I did on technology. Then we wanted to speed the court up. Now, Chris had gotten all the judges, so, you know, there'd been a dramatic improvement in our backlog, but, you know, we didn't get all the cases out we heard in the year. And, you know, there'd be cases that would sit around for a long time. And there would also be cases, judges who insisted on staying in the rotation because they liked to sit, but it was piling up like Lucy in the Chocolate Factory. So we nicely said that if you fall behind, we're going to take you out of the rotation. And at first there was some resistance to that, but then we used the tool that works best with judges, which is bribery. We offered them a champagne that I promised to pay for, a champagne party at the end of the summer if everyone had gotten all their cases done. And we actually did have a party. My favorite moment, perhaps when I was on the appeals court, I don't know if Justice Hanlon is here. Now, Justice Hanlon is one, when she's disgruntled, you know the big cats? That's a saber-toothed tiger. She's in a class of her own. But my happiest moment is when she came to me at the party and said she was going to have a guilt-free end of the summer for the first time on the appeals court because she was fully caught up. So I knew that I'd accomplished my major managerial objective at that point. The last thing is the judges and the staff that we brought in. Now, really, Lon Povich deserves much more credit for the judges than I do, but I'm looking out at the audience. Judge Wendland, Judge Shin, Judge Desmond, Vicki Henry, all arrived. They were among the very first judges that came. We became much more diverse. Then we brought in some diversity in geography. I see Judge Kinder came from, we dragged him out of Western Mass briefly. Then we actually got really top civil lawyers who gave up their millions of dollars like Judge Nyman and Judge Englander. And the court really started to change pretty dramatically. And then we changed the staff. We brought in a probate specialist, a commercial law specialist who the SJC has successfully stolen, Tim McGuire, who's fabulous. And also I think we had a real estate and mortgage people, so we made the staff specialized. And then at Judge Cohen's help, we did probably the most important thing that happened while I was there, which is we created a legal assistance clinic, an appellate legal assistance clinic for unrepresented unrepresented defendants and plaintiffs, which is the first in the country, and I think really made a big difference because you can't practice appellate law by yourself if you haven't been to law school. So that was what we did. And then I did what Judge Brown liked to say, I got out of Dodge.
Justice Green. You came in when Judge Kafker got out of Dodge and found what he had left behind for you. That, however, paled quickly, I would assume, with the arrival of the pandemic. Would you like to perhaps briefly tell us what initiatives you were considering important before COVID hit and then how that required an adjustment?
Well, I guess I'll start by saying a couple of things. First is that Scott and I shared a lot of common visions of what we needed to do and how we needed to do it, and we really worked very well together. Along with Justice Cipher while she was there. We used to joke that the three of us, among these expansion judges, were so much younger than everybody else that at one point we'd get to a point where it was just the three of us left, and then the two of them abandoned it. So a lot of what I set out to do was very much along the lines of what Scott had set out to do. The difference being that I had been there a couple of years longer by the time I became chief, even than he had been when he was chief. But I'm a slow learner, so I was not afraid to try shaking things up a little bit and making a little bit more change at a little bit more rapid clip. Now, some of that worked and some of it didn't. Some of it ran into some frustrations but we learned from our mistakes. And then COVID. So I think all of us will remember where we were on maybe those couple of days before March 13th of 2020, and certainly from the 16th, 17th, and on. At the appeals court, we spent those early days calling the staff in from their homes for brief surgical strikes. We arranged for temporary parking on the plaza for them to come downstairs, so that we could shove computers into their hands and send them home with a set of instructions. I asked my two law clerks to learn how to use Citrix so that they could serve as a telephone help desk for people who had never worked remotely before and divert those help requests away from our overtaxed IT support staff who were working along with Joe Stanton to build the Zoom and YouTube platform that allowed us to get started doing video conference oral arguments 2 weeks later, as ridiculous as that sounds. So we were up and running. We paused the arguments for April, but we were up and running for all cases with Zoom arguments by the time of the May sitting, and continued doing so effectively through the end of the 2020-2021 court year, and only came back to the building in July when it was clear that at least at that point in the pandemic we could do so safely. After that time, as we've gradually tried to navigate the latter stages of the pandemic and migrate back to the point when we can sit in a room like we can today, we've leveraged some of that learning, and we now have the ability to project not only our Zoom arguments but our in-court arguments out to the general public. Another initiative that I had in mind that has taken several tries, but we're trying the latest iteration announced last Friday to allow for full en banc review of cases that might otherwise require the so-called Shaba protocol for split decisions. That protocol has long been a source of frustration and concern by members of the bar who see a case come out where the outcome was determined by people who did not participate in argument or sit on the original panel. So one of the obstacles to true en banc has always been the question of where do you put all the judges if you're going to have 25 judges sitting in a hearing. The answer to that now is that we've got a very small Brady Bunch set of boxes across the screen, and we can do a Zoom argument. We'll see how it works. We announced it as a pilot, and we will assess that experience at the end of a period of time and determine whether it works, whether it doesn't, and what adjustments we might need to make.
I wish that we could hear more from each of you individually. But what I'd like to do now is to throw out some questions for discussion. And I'm hoping that this first question will particularly pique the interest of Justice Graney and Justice Kafker, because it has to do with the appeals court role in the judicial ecosystem. Is the appeals court just a workhorse for deciding large numbers of cases, or does it play a critical role in the development of the law?
So I can remember a New England Judges Conference where Justice Graney was talking to us about state constitutional law. You were on a panel, and someone asked you a question, well, what should the appeals court do there? And you told us to be bold. And I remember sitting there thinking, yeah, we'll be bold, and then his colleagues will kick our butts. And I still sort of believe that. I believe that, the appeals court really does have a law advancement, process there. But it needs to be done incrementally and carefully. I think you can polish off the rough edges in the law and fill in gaps, but if you start creating new tests and changing direction dramatically, we'll probably, on the SJC, intervene. The analogy I think of is Justice Granger is a skier, and I'm not a skier, but I look at the appeals court as having to do slalom. You have to go in and out of all the gates we set, and it's very difficult, and we actually get to rearrange the gates. It's really easy. So.
Justice Graney, what's your take on that?
Well, I think Chief Justice Kafker used the right word. My approach was to be bold, and if the case ended up here and the SJC staff who had looked at it hadn't recommended it be taken there, and it contained an important and maybe an issue of first impression, then it was for us to decide, and we would do it. I'd have to say in the SJC's eternal gratitude was if we decided something that was very controversial, of course they'd take some, or we broke new ground, they'd take some. But if they were happy with our reasoning and what we decided, they would let it stand and it wouldn't go on further appellate review. The example that I remember about that was my colleague to my right wrote one of the first decisions on terminating life on someone who is gravely ill and about to die and is incompetent. That was Sakowitz, as I recall it. And Chief Justice Armstrong wrote a marvelous opinion on that, and the SJC left it alone. A couple of years later, they had their own cases, and I reread those before I came down, and one in particular, Chief Justice Liakos, basically copied the reasoning of Chief Justice Armstrong in that case. So that's just one example of many. And one more word, occasionally we would run into a case of the SJC that was very difficult to distinguish, but had to be dealt with because it was on all fours, so to speak. And I remember going to Justice Grant in my first problem with that, and I said, "What do I do now with this?" And he said, "Cut his throat in a footnote," which I did, and that was the end of that. True, it's absolutely true.
So the appeals court can be not just a substantive forerunner, but also a procedural laboratory in adopting new ways of doing things that perhaps would encounter less resistance, or at least a longer look-see. An example is what Justice Kafker mentioned, which is the Clinic for Self-Represented Litigants. For the panel as a whole, are there other innovations, technological, procedural, or otherwise, that, in your opinions, the appeals court might experiment with?
I'm going to suggest that maybe we go back to Chief Justice Raposa for a minute, because if I'm remembering correctly, the very first sticking the toes in the water with technology did come under your watch.
It did. During the fiscal crisis that you've already heard too much about, it became obvious that in order to keep up with the work and in order to prove to the legislature, if nobody else, that we were up to the task, we realized we were working as hard as we could, but we had to work smarter, not in an intellectual sense, but in a technological sense. And that was something that we had not yet addressed. We still had judges who were doing quite a bit of their writing on legal pads. I've heard various stories about judges who still did not have the technical ability to even type out a document, to do an email, and this may all sound so foreign to the younger members of the audience, but that was the case. I remember when we left the high-rise next door and moved into our new quarters, first in Center Plaza and then here, Justice Jim McHugh and I wanted to take a souvenir from the high-rise, so we opened a drawer, and there we took out a box, and it was a box of metal nibs that you use in a fountain pen. So that gives you some idea of where we stood. So in deciding to work smarter and not just harder, what we did was we started a series of education programs, learning how to use WordPerfect when we still used WordPerfect, learning how to use that newfangled thing called email, how to attach documents to emails, things of that sort that people just didn't know how to do. This not only increased our ability to do our work, but also to communicate with each other, which is also very important as we found ourselves spread out over a wide area, for example, in Center Plaza, where we had people on different floors, and we had outlying regions which we called pods, which somewhat science fiction-y term for it, but people needed to be able to communicate with each other. In 2009, we launched our first website, which provided information to the public. We were learning along with the public about what the court could do for purposes of outreach, educating the public. And in educating the public, we educated ourselves, because I think it made us better realize what potential we had to accomplish our mission. We took our first steps in the direction of e-filing, which was something very out of the ordinary, but something that we realized, while the road was a long one and is still being walked by the appeals court, that we had to start down that road. E-filing was something that was very important in that regard. I know I asked then Justice Green and Joe Stanton to work together to oversee this process, and I think it's fair to say the rest is history. It took a lot of work. Justice Kafter picked up the torch and ran with it much faster than I did, and did a great job. But it was extremely important to keep up with the legal profession. We were falling behind the legal profession, and that was something that we could not allow. We also circulated iPads for the first time to judges, where judges could now access materials digitally through electronic means. My first high-tech purchase when I came to the appeals court was to buy more plastic crates for the trunk of my car to haul files home, and that was my first high-tech purchase. At least when I left and retired as Chief Justice, at least we were working in a more digital environment than we had previously. So those things were very important, and it also maybe even contributed to, I know one of the questions you're going to be asking about common purpose, but I'll leave that part of the comments to then.
I see.
I just want to add
Chief Justice Green is squirming in his chair. Because this is his favorite topic.
I picked the right person.
One of many. No, but I do need to jump in because he's understating somewhat. A lot of things happened after Chief Justice Raposa's departure as chief, but there were two major steps that were integral to everything that followed. The first, Joe Stanton and I were just reminiscing about this earlier today with Chief Raposa, and that was we had worked up a review and a set of recommendations and came to Chief Justice Raposa with a proposal and a recommendation that we, as we adopted e-filing, that we have a single stream of content coming in through e-filing alone. And what I mean by that is that many courts around the country, in fact, in my activities with the National Organization of Intermediate Chiefs, many courts still do this. They have parallel sets of filings, electronic filings, and then a separate set of briefs. And as Joe pointed out, that doesn't reduce the workload. It increases the burden placed on the clerk's office staff, because not only do they need to manage the e-filed stream, but they need to reconcile the identity of the paper-filed stream and store and manage that paper content. We ginned up our courage, went in for the meeting, and to our amazement, we came out of that meeting with an approval to move forward on that process, and really nothing could have happened the way it has since. The second was he mentioned the iPads. Several of us, Judge Cohen, Chief Justice Kafker, and I, had started in the early 2010s. Experimenting with what an iPad could do. We were joined by some people who were not so tech savvy, Justice Hamlin, Justice Carhart. And it was their participation that illustrated that you didn't have to be all that tech savvy, and you could acquire a great deal of convenience to have all of the content you needed instead of hauling it around on the bus with these big boxes. You had everything you needed at your fingertips, and it was just a matter of learning a few little tricks of how to use that app. So it had grown organically because of user demand. By around 2014, we had a little bit of money left in the end of the year for the budget. We had a little bit of money left to put Wi-Fi into the Adams Courthouse, and those two things combined allowed us to integrate finally end-to-end digital content management. And as judges retired who did not like doing it that way, they were replaced by people to whom we simply handed the iPad and said, "This is the way we do things here at the appeals court." I'm looking at one of them who just now has reminded us that not all of them are in that category. But we'll bring you around, Englander. Anyway, I don't want to have lost in the overall story of technology at the appeals court the critical role that those seminal decisions made under Chief Justice Raposa's watch.
I'd say that Chief Justice Raposa, Chief Justice Kafker, and you have been transformative figures in that regard, and really made an enormous difference. I can tell you in my own life, since carrying those litigation bags around with me was not good for me. Another question, though, that was adverted to, and I'm hoping maybe Chief Justice Armstrong will weigh in on this, because he was particularly masterful at this, and that is, what, if anything, can a chief do to foster collegiality? And how important is collegiality to the healthy functioning of the court?
In my day, collegiality was critical. It made from taking the model from Judge Graney's day, making the judges get along with each other, feel that they are part of a team, making the staff feel that they are part of that same team, creates a very happy court, a court in which everyone is invested in the same goals, and it was critical. Whether it still is in the digital age, I don't know.
Well, as the justice who had the unenviable task of following in the footsteps of Chris Armstrong as Chief Justice, I have to second what he said. The sense of a common purpose is a very important one in an organization that is always evolving. We've evolved in terms of our size, in terms of our membership, in terms of how we do work, in terms of where we've been located, in terms of how we've used our resources. And it brought to mind something I heard once, which is it's not a matter of survival of the fittest, it's a matter of survival of those who can adapt. And the appeals court is a place where people have adapted over time, and that ability to adapt is something that I think, to use the term used by Chief Justice Armstrong, in which everyone is invested, because everyone benefits from it. If you've had a chance to look at the Appeals Court at 40 book, one of the phrases that is used throughout is we refer to the appeals court family, because we are a family in which everybody has a role, everybody has a purpose, everybody should be treated with dignity. As with every family, there are problems. We can at times be dysfunctional, so I'm not getting all rainbows and unicorns on you. But it's a very important concept to strive for, even on those occasions where we're not successful. I've served on international tribunals where we're setting up a court, and the first thing you realize is you can't just put judges in a building and call it a courthouse. You have judges, you have clerks, you have law clerks, you have staff attorneys, you have support staff, you have IT. And to use a phrase used earlier by Justice Cohen, it is an ecosystem in which we all depend on each other. So all of these things have to be taken in that context. And while you don't have a judge without judges, you don't have a court without judges, judges are not enough to make a court. And the appeals court is no exception from that. So I second what Chief Justice Armstrong said about the importance of the appeals court as a family where we work in a collegial, friendly, and mutually supportive manner.
We are almost out of time. We're going to try one more question. I'll start with Judge Kafker, who had the bad luck to be sitting next to me. Visions for the future. Do you have any speculation as to what the appeals court will look like in the next 10 years or 20?
So I'd say two things on that. First, the appeals court's always been filled with like super smart judges and managing, this huge docket. So I think that's always going to be the same. I think that it's also going to be challenged technologically. I think what Chief Justice Green just did, this virtual panel for en banc, and what you guys all did in Zoom, which we copied at the SJC, there's going to be more of that, a blurring of, virtual and in-person hearings, particularly the younger lawyers. They're all cyborgs at this point. They're completely comfortable being virtual and in-person. But I would say one last thing, which is the Chief Justice panel 20 years from now is going to look very different from this. It's going to be chock full of women and judges of color who are in this audience, and they're going to actually decide what this court's going to look like 20 years from now, much more than I think the old guys here. So I'd be curious what they think.
Bravo.
Shall we give Chief Justice Green the last word on what he thinks about the future?
Well, with some peril, I guess I'll combine together a couple of themes that have just come across. One of the things that one of the other innovations we did coming out of the pandemic was to continue what had been very successful during the pandemic and during the latter stages of the pandemic, and that is we adopted a formal remote work policy that structured and authorized staff at all levels to be working a good deal, actually a majority of their time if they choose, outside the building. But with that comes the challenge of how do you establish with new hires and preserve and cultivate with the old hands the kinds of collegiality and collaboration that are essential to an appellate court. Nothing that goes out of the appeals court is only touched by one person. And for it to be successful, everything needs to depend on the efficient functioning together of people who share that common purpose, and that happens when people have a chance to interact with each other and get to know each other, to trust each other. And so we're working very hard to find different ways to do that in this new world order. I think it's really the challenge of innovating on the fly, trying to find what might be available and what's new, but preserve what's essential to who we are. It has been fascinating to me to look back across all of this time and to recognize, despite all of the change, how much is the same from the very beginning.
Well, on that note, I think we should thank these 5 remarkable chiefs for their service and for being here today to share their reminiscences and educate us a little bit about what really goes on behind the scenes. So thank you so much.
Yes, thank you.